Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.
People v. Jarvis Lewis. Decided March 19, 2026. Singus. The trial court repeatedly informed defendant that it would not appoint new trial counsel, warned defendant that his trial would continue in his absence, and asked defendant whether he wished to proceed with his counsel's representation or represent himself. In response, defendant told the court that he fired his attorney, refused to respond to the court's attempted colloquies regarding his rights, continually left the courtroom when addressed, and refused to attend the trial. Under these circumstances, we hold that defendant, by his conduct, waived the right to the effective assistance of counsel. We also hold that the trial court erroneously imposed consecutive sentences for 2 counts of criminal possession of a weapon in the second degree under different theories, because the offenses arose from defendant's single act of possession. We therefore modify the appellate division order accordingly. 1. In 2007, defendant was convicted of first-degree rape following a jury trial and sentenced to 12 years imprisonment. While on parole, in May 2021, defendant walked up to a vehicle in Rochester, removed a firearm from his waistband, and fired 2 shots into the vehicle, injuring 2 victims. 2 weeks later, officers located and approached defendant and told him they wanted to speak with him about their investigation. Defendant then attempted to flee, and the officers chased and tackled him. During the ensuing struggle, defendant reached for a gun in his waistband, which the officers seized. Defendant was charged with, among other crimes, 4 counts of second-degree criminal possession of a weapon, 2 counts for each incident date under different theories of possession. See Penal Law 265.03 1b, intent to use unlawfully against another. 3. Simple possession. Defendant retained private counsel about a month before trial. In that time, defendant's counsel appeared at 3 pretrial conferences and successfully moved to preclude the people's firearms expert from testifying at trial. The day trial was scheduled to begin, defendant appeared in the courtroom dressed in his prison uniform and read a statement requesting that new counsel be assigned. Defendant claimed that his attorney was not acting in his best interest because the attorney had not provided defendant with discovery and other documents he requested, but defendant did not specify which documents his attorney had not given him, and counsel did not recall whether defendant had made any such requests. Noting counsel's competent representation throughout this case and others, Supreme Court denied defendant's request, stating that it was simply an attempt to delay the trial. Explaining that it was ready to go, the court informed defendant that his attorney would represent him throughout this process and repeatedly asked defendant why he was not dressed in civilian clothing. Defendant did not answer. Instead, defendant reiterated his belief that his attorney was ineffective and stated that he did not have anything else to say on the record and that he was not moving forward with the trial. In response, the court repeatedly warned defendant that the trial would proceed and asked defendant if he wished to change into civilian clothing, warning defendant of the prejudice he could suffer by appearing before the jury in a prison uniform. Each time the court attempted to ask defendant further questions, he remained silent in response. The court then directed an officer to bring defendant to a holding cell and give him another opportunity to change into civilian clothing and return to the courtroom. The court warned again that if defendant rejected that opportunity, we will begin the trial. After a recess and outside defendant's presence, the court explained that defense counsel had spoken with defendant in the holding cell upon the court's request. According to defense counsel, defendant reiterated that he did not want counsel as his lawyer going forward, objected to the trial going forward, was not coming to court, and had requested that the deputies bring him back to the jail. At this point, the court ordered counsel to tell defendant that his requests are denied in all respects and that the court anticipated moving forward with counsel as his attorney and in his absence because he's chosen to forego his constitutional right to be present for trial. Counsel relayed this message. After another recess, defense counsel told the court that he and defendant had an additional conversation in which defendant instructed counsel that he did not wish for counsel to represent him in this trial or to participate in the proceedings, and in fact, he directed counsel to leave. The court then told a court officer to go down and tell defendant last chance to come into the courtroom, and if he refuses, we will proceed without him. After yet another recess, the officer testified that defendant continued to refuse to change into civilian clothing or be present for the trial. The court ordered counsel to represent defendant irrespective of the circumstances and informed counsel that if at any point during the course of this proceeding, defendant changes his mind and indicates that he wants to be present, we would love to have him here. Defense counsel then reiterated that defendant explicitly instructed him not to participate in this proceeding and instructed him to leave. Counsel explained that he was on the horns of a dilemma and, quite frankly, did not know what his ethical and legal obligations were, given defendant's instructions to him. The court acknowledged that the situation was a little bizarre and said that it was ordering defense counsel to be here as defense's attorney. The court explained that the trial would move forward and ordered defense counsel to remain in the courtroom to represent defense's interests and told counsel, whether you do anything or not is up to you. Following an additional recess, the court brought defendant into the courtroom. The court began by stating, "One of the fundamental cornerstones of our Constitution and our criminal justice system is that you're entitled to a jury trial, and that you're entitled to participate in that jury trial, and that you're entitled to participate in your defense. You're also entitled to take the stand if you so choose during the trial. Now, you and I have had some conversations on the record, and you don't really want to be here. You've also apparently indicated to defense counsel, because I've ordered him to come see you and have the conversation with you about the importance of you being here and participating in your defense, and he's indicated a couple things. Number one, you absolutely don't want to be here, and number two, you fired him and told him you don't want him to represent you. So I'm just going to ask you a couple questions. You have the opportunity to be here and be present during your trial. Would you like to be here and be present during your trial?" Defendant responded, "Your Honor, I object to this whole thing, and I fire defense counsel as my lawyer, and I have no more things to say. Can I go back to the jail?" At this point, the court asked defendant if he was waiving his right to be present during the trial. Rather than responding, defendant began leaving the courtroom. Noting that defendant had the right to leave, the court asked him, "If you're going to fire defense counsel, do you want to represent yourself?" Defendant again demanded another attorney, and the court reiterated, "I won't give you another attorney, but you're free to represent yourself if you wish." Defendant then left the courtroom. Addressing defense counsel, the court observed that, in the last week or two, at least 2 other judges had confronted the same attempt by defendants to cause error for purposes of appeal. The court ordered defendant's attorney to remain present for the trial as standby counsel, and counsel reiterated his intention to follow the instruction of his now former client and not participate at all in these proceedings. The court then summoned the venery, excused several prospective jurors, and adjourned. The court attempted, to no avail, to communicate with defendant about his rights and his decision not to participate on various occasions throughout the trial. On the first day, defendant again appeared in his prison uniform, remained silent when addressed by the court, and refused to identify himself for the record. The court stated that defense counsel was and is going to continue to be defendant's attorney, and explained that it had summoned defendant to make sure he understood the ramifications of his decisions. The court then asked defendant if he understood that he had the right to assist in his defense, confront adverse witnesses, testify on his own behalf, and be present at the trial in civilian clothes. Each question was met with silence. In its remarks, the court again observed that there has been a pattern of behavior, especially with those who have been incarcerated in the Monroe County Jail and who have had prior criminal justice experience, in attempting to delay trials by trying to fire their attorneys at the last minute and being otherwise difficult. The court further warned defendant that firing his attorney was not going to happen and that the trial will proceed today. Defendant responded, "Your Honor, I fired defense counsel and I do not want to be here." The court again stated that it had ordered counsel to represent defendant and again asked defendant if he wanted to represent himself. Defendant did not answer and instead left the courtroom. The court resumed jury selection, at which defense counsel was present but did not participate. On the second day of trial, with defendant present, the court yet again explained to defendant that it had ordered defense counsel to remain as his counsel and advised defendant that it was very important that he know how detrimental his failure to be here is. The court also asked defendant whether he had instructed his attorney not to do anything. Defendant began leaving the courtroom rather than responding, and the court threatened him with a contempt charge. Defendant then replied, "I fired defense counsel. I don't have to do this." The court continued attempting to engage defendant in a colloquy, again to no avail. The court: "I just want to make sure you understand what you're doing to yourself. You have an absolute right to be here. You have an absolute right to confront witnesses. You have an absolute right to have defense counsel assist you. You have an absolute right to represent yourself, but you told me you didn't want to. Do you want to represent yourself?" The defendant: "I fired defense counsel, and I chose not to be here, Your Honor." The court: "Okay, so I'll assume that that means you don't want to represent yourself, and I told you I won't let you fire defense counsel 2 minutes before the jury walks in the courtroom. And defense counsel told me you told him not to do anything, just to sit there. Is that right?" The defendant: "No." The court: "What did you tell counsel about his representation of you?" The defendant: "Nothing. I fired him, and I chose not to be here." The court responded by reiterating defendant's right to be present, strongly suggesting that defendant be present, advising defendant of his rights to give opening and closing arguments, cross-examine and confront witnesses, and have his attorney put on a case, asking whether defendant wanted to avail himself of any of these rights, and explaining yet again that at this late stage, defendant could not fire his attorney. Defendant responded by repeatedly claiming that he had fired defense counsel and counsel no longer represented him, and stating that he did not want to be in the courtroom. Defendant then left, and the trial proceeded without him. Defense counsel again remained present but did not participate. On the third and final day of trial, defendant was again brought into the courtroom. The court noted that the people had presented an opening statement and 10 witnesses, and that we may very well close proof today. Again, attempting to engage defendant, the court asked whether he was aware of his right to be present and assist in his defense, and defendant did not respond. The court really strongly suggested that defendant be present and warned that defendant was making a huge mistake. The court observed that defendant told defense counsel not to do anything on his behalf, repeatedly explained that defendant could choose at any time to be present for the remainder of the trial and could also choose to represent himself, and again described many of the rights that defendant was foregoing through his absence. Defendant either repeated that he had fired his attorney and wished not to be here, or remained silent in response to each question, and he walked out of the courtroom before the trial resumed. At the close of the people's case, outside the jury's presence, defense counsel moved for a trial order of dismissal, rested, and did not otherwise participate. The people gave a closing argument and participated in responding to jury notes without defense counsel's input. The jury then convicted the defendant on all counts. For the shooting, Supreme Court sentenced defendant to 10 years imprisonment for possession of a loaded firearm with the intent to use it unlawfully against another, count 1, and 10 years imprisonment for simple possession of a loaded firearm, count 2. For the crimes arising from his arrest, defendant was sentenced to 10 years imprisonment for possession of a loaded firearm with the intent to use it unlawfully against another, count 3. 10 years imprisonment for simple possession of a loaded firearm, count 4. 5 years imprisonment for second-degree assault, count 5, and 1 year's imprisonment for resisting arrest, count 6. The court ordered the sentences on all weapon possession counts, 1 through 4, to run consecutively to each other, and the sentences on the assault and resisting counts, counts 5 through 6, to run concurrently with those counts. The appellate division affirmed, with 2 justices dissenting. The dissenting justices would have held that defendant did not waive the right to effective assistance of counsel and that his attorney failed to provide meaningful representation by complying with defendant's instruction not to participate in the trial. A judge of this court granted defendant leave to appeal. 2. A. Waiver is a knowing, intelligent, and voluntary relinquishment of a known right. People v. Sargent. Like other fundamental rights, a defendant's right to effective assistance of counsel may be waived. See People v. Henriquez. We have explained that an accused awaiting trial has only 2 choices regarding legal representation: proceed with counsel or waive the protection of the Sixth Amendment and proceed pro se. Accordingly, when a defendant refuses self-representation and restricts the participation of counsel, they have voluntarily waived the right to the effective assistance of counsel. Whether the waiver of a fundamental right is valid depends, in each case, upon the particular facts and circumstances surrounding that case, including the background, experience, and conduct of the accused. Johnson v. Zerbst, see People v. Seberg. In many instances, the requisite affirmative showing that a right has been knowingly, voluntarily, and intelligently waived will include a direct colloquy between the court and the defendant, People v. Myers. We have also long held that a defendant may waive certain fundamental rights by their conduct, most notably in the context of the right to be present. See e.g. People v. Dunton, People v. Parker, People v. Johnson. See also Taylor v. United States. In determining whether such a waiver occurred, relevant circumstances include the warnings provided by the trial court, the defendant's actions in response, and whether, in light of the defendant's conduct, the trial court could practicably have administered additional warnings or attempted to secure an oral waiver. In People v. Epps, for example, the defendant refused to leave his cell to attend the trial as part of a prisoner boycott of the courts, despite the court's warning that the trial would proceed without him. We held that the defendant waived his right to be present, notwithstanding that he was not brought before the court to state his waiver on the record. Eschewing an overly rigid approach, we reasoned that requiring officers to bind and shackle the defendant and deliver him by force merely to pronounce a pro forma waiver would not only have constituted an empty gesture, but on these facts may well have precipitated a more serious disturbance. We observed, too, that allowing the defendant to abort the trial merely by refusing to leave his cell would make a travesty of our criminal justice system. Applying these principles, this court and others have recognized that a defendant's right to effective assistance of counsel, like the right to be present, may also be waived by conduct. See People v. Kelly, United States ex rel Testamark v. Vincent. See also Henriquez, Collecting Cases, People v. Higgins, United States v. Nichols. In People v. Kelly, for instance, defense counsel remained mostly silent after the defendant asked for counsel to be relieved, and the trial court's efforts to ascertain whether the defendant wanted to be represented by counsel or wanted to appear pro se were met by unresponsive statements that the defendant would be judged by Allah and that Allah would advise him. The appellate division was at a loss to understand what else the trial court should have done after its fruitless effort to ascertain what the defendant wanted. Reasoning that an experienced criminal defendant should not be permitted to nullify a trial and require a new trial by the simple expedient of obstructing every effort of the court to assure to the defendant his legal rights and a fair trial. The court stressed that a criminal trial is not an obstacle course for the judge, and there comes a point where a defendant must bear the consequences of their conduct in a courtroom as well as out of it. The court therefore affirmed the defendant's conviction, as did we, adopting that court's reasoning. B. In light of the trial court's many warnings to defendant and defendant's obstructive behavior in response, there is record support for the conclusion that, by his conduct, defendant waived the right to effective assistance of counsel. A trial court must be cautious not to conflate waiver of the right to be present at trial with waiver of the right to effective assistance of counsel. These rights are separate, and a trial court has distinct duties to ensure the validity of a defendant's waiver of each. However, in certain circumstances, as in this case, the same conduct may amount to a waiver of both rights. Here, defendant has never contested that he waived the right to be present, and the record makes clear that he did so, including by continually absenting himself from the proceedings. In addition, the court repeatedly and unequivocally denied defendant's requests for new counsel and explained that defendant would not be receiving substitute counsel. The court also continuously reminded defendant that he could choose to represent himself or authorize his attorney to participate in the proceedings at any time, options that defendant unequivocally repeatedly refused. The court likewise gave defendant numerous warnings and attempted to provide several more regarding the fundamental rights at stake, and made clear at least 5 times that it would not suffer defendant's delay tactics and that his trial would proceed. Faced with this situation, defendant directed his attorney not to participate in the proceedings and insisted 10 times, despite the court repeatedly advising him otherwise, that he had fired his attorney. In response, the court directly posed to defendant the choice between proceeding with his attorney or representing himself. And faced with this choice, in an apparent effort to obstruct the proceedings, notwithstanding the court's warning that the trial would continue, defendant chose to simply leave the courtroom, knowing that the trial would proceed without him. Defendant thus anticipated and desired that his trial would proceed just as it did, both outside his presence and without him or his lawyer mounting a defense. Defendant's intention to obstruct the trial is also made plain by his persistent refusal to change into civilian clothing and insistence on absenting himself from the proceedings in response to the court's many efforts to engage with him. Indeed, the trial court observed that multiple other defendants had recently engaged in such tactics in other courtrooms in the county. Moreover, defendant had previously been tried and convicted by a jury, prior experience that further indicates he understood the importance of having trial counsel's representation. And when the court informed him each day of the status of the trial, including on the last day of trial, that the people had presented opening argument and 10 witnesses in his absence, defendant made no objection, expressed no surprise, and continued his obstructive behavior. These facts show that at the time of defendant's waiver before trial began, defendant was well aware of the nature and importance of the right to meaningful representation and knowingly chose to forego that right. See People v. Blue, explaining that the court may look to the whole record when assessing a defendant's knowledge at the time of waiver. Under the totality of these circumstances, defendant waived the right to be present and the right to effective assistance of counsel. We confronted similar circumstances in People v. Henriquez, in which the defendant instructed his attorney not to participate at trial and refused self-representation, even though the court explained the magnitude of the decision facing the defendant, repeatedly informed the defendant of his right to utilize the services of his attorney, and directed defense counsel to remain available. We held that the defendant's desire to prevent counsel's participation, coupled with his adamant refusal to represent himself, translated into an intentional failure to avail himself of his constitutional right to a fair opportunity to defend against the state's accusations. The record in this case supports the same conclusion. See Higgins. The defendant willfully decided to forego any representation or to assert any defense unless the trial court granted his demand, to which, concededly, he was then not entitled. The defendant's position was substantively equivalent to an express waiver of counsel, since he adamantly refused to proceed with the assigned counsel to which he was properly limited. Cf. United States v. Moore. Under the federal standard for waiver of the right to counsel, a persistent, unreasonable demand for dismissal of counsel and appointment of new counsel is the functional equivalent of a knowing and voluntary waiver of counsel. Defendant argues that his waiver was invalid given that the trial court's pretrial colloquy here was less thorough than the one we deemed adequate in Henriquez. While it is true that the trial court did not explicitly ask defendant whether he wished to waive the right to effective assistance of counsel, as is usually required, the only conclusion to be drawn from defendant's behavior throughout the colloquies is that he waived that right by his conduct. Prior to and throughout the trial, the court repeatedly attempted to engage defendant in colloquies to advise him of his rights, but each time, defendant prevented the court from engaging in a more fulsome colloquy by refusing to respond when addressed and continually walking out of the courtroom. We decline to require a court to forcibly restrain a defendant in this circumstance, as that would be an impracticable, empty gesture. Epps, C. Henriquez, Dunton. We also reject the dissent's contention that the court could have replaced defense counsel or ordered defense counsel to represent defendant. As to the former argument, defendant does not challenge the appellate division's unanimous holding that the trial court properly denied his request for new counsel. As to the latter, the dissent provides no legal authority for its suggestion that a judge can dictate the strategy or conduct of a litigant's attorney, and in all likelihood, that solution would overstep the trial court's authority. People v. Hills, it is not for the trial justice, no matter how well motivated, to usurp the role of counsel for either side in a criminal trial because of the court's conception as to how the case should be presented. People v. Arnold, a court may not, however, assume the advocacy role traditionally reserved for counsel. Edwards v. United States, defense strategy and tactics are a matter for decision by the defendant and their counsel without interference by the court. We therefore conclude that defendant, by his conduct, waived the right to effective assistance of counsel. 3. We turn to defendant's challenge to his consecutive sentences. The people concede that defendant improperly received consecutive sentences on the 2 counts of simple possession, counts 2 and 4. We accept the people's concession that the sentences on counts 2 and 4 should run concurrently. That leaves us to determine, with respect to each underlying incident, the legality of the consecutive sentences for simple possession and possession with intent to use. Concurrent sentencing is required when more than one sentence of imprisonment is imposed on a person for 2 or more offenses committed through a single act or omission, Penal Law 70.25(2). In determining whether consecutive sentences are permitted, a court must determine whether the actus reus elements of the offenses are, by definition, the same, People v. Laureano. If so, the people may yet establish the legality of consecutive sentencing by showing that the acts or omissions committed by the defendant were separate and distinct acts, e.g., People v. Ramirez, People v. Braithwaite, People v. Brown, People v. Truesdell. Although this court has previously addressed consecutive sentencing in the context of weapons possession and interrelated ensuing substantive crimes, People v. Wright, possession with intent to use and murder, e.g. People v. Billups, decided today, simple possession and murder-robbery, we have not yet had occasion to analyze consecutive sentencing where two possessory offenses, simple possession and possession with intent to use, are at issue. Here, we agree with defendant that his consecutive sentences for simple possession and possession with intent to use with respect to each incident are improper because the offenses actus rea are the same. See Penal Law, Section 70.25(2), Laureano. A person commits the offense of simple possession of a weapon by unlawfully possessing any loaded firearm, Penal Law, Section 265.03(3). This is accomplished by exercising domination and control over such a weapon, People v. Okafor, People v. Brown, an act that, by its nature, is continuous and may go on for hours or days, right? Meanwhile, a person commits the offense of possession of a weapon with intent to use by committing the same actus rea, possessing a loaded firearm, with the mens rea of intent to use the same unlawfully against another, Penal Law, Section 265.03(1)b. The statutory actus rea for these offenses are therefore identical by definition, Laureano. As such, to establish defendant's eligibility for consecutive sentencing with respect to each incident, the people bore the burden of showing that defendant's possession of the gun for the simple possession and possession with intent to use crimes arose from separate and distinct acts. The people failed to shoulder that burden on this record. Thus, the sentences for counts 1 and 2 must run concurrently, as must the sentences for counts 3 and 4. Accordingly, the order of the appellate division should be modified in accordance with this opinion, and, as so modified, affirmed. Order modified in accordance with the opinion herein, and, as so modified, affirmed. Opinion by Judge Singas. Judges Rivera, Garcia, Canataro, Troutman, and Holligan concur. Judge Holligan in a concurring opinion. Chief Judge Wilson dissents in an opinion. Decided March 19, 2026.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.